acquiring and holding interest in real property. So how do we acquire an ownership in real property? Well, first of all, we acquire it upon death of the property owner, and that happens in two ways, either by inheritance, which in that case there is no will, and or by a devise, and that is where someone does leave property in a will. That's what a devise is. It's a gift of property in a will. Then, of course, you could also have a lifetime gift. People all the time will give a gift deed of their real property to a loved one or for love and affection. That would be an example. Then, of course, very common is people just want to sell their property, need to sell their property, and they make a contract with a potential buyer, and then they close on the sale. So it's a contract and sale, very common. And then, of course, not so common, but you may see this in the news sometimes, something we call adverse possession. And I jokingly refer to it as theft of real property, but you really can't steal real property. You can't carry it away, but that's basically what's happening here. Someone is claiming the real property as their own when in fact they don't have any title to it, and they hold it in conflict, in opposition to the real owner, possess it, use it in conflict to the record owner for a sufficient period of time so that the record owner misses a statute of limitations to kick out the adverse possessor. And so if they miss a statute of limitations, what happens? Well, you don't have a lawsuit anymore. But these statutes of limitations are frequently very long, and different states have different lengths of statutes of limitations depending on the circumstances. So that's basically what adverse possession is. It's a statute of limitations. And then finally, there's one last notion with adverse possession called tacking, where an adverse possessor, a series of adverse possessors, can take their periods of possession and tack them together to apply against the statute of limitations. So how do we hold real property once we have acquired it? Well, obviously you can own it solely, have sole ownership. But what we're interested in at this point are a number of ways where we have concurrent owners owning the property, and there's several different ways that can happen. And I'm going to address in Texas. Now, first of all is tenants in common. Then we have something called joint tenants with right of survivorship. Then we have something called community property. So let's take a closer look at each one of these three. Starting with joint tenancy with right of survivorship. With a joint tenancy with right of survivorship, each owner owns an equal undivided share. Now, when we say undivided, that means all the owners own all of it together. They have certain rights to all of the tract of land. They can't say, well, that corner of the tract of land is mine. In that case, it would be divided among them. This is undivided. So each owner has an ownership interest in the whole, and each owner has a right to use and possess the whole. And each owner, however, in a joint tenant with right of survivorship, each owner has to have what we call the four unities. There's four concepts that have to come together that all of the joint tenants have to have. First of all of the joint tenants have to have the same interest. In other words, the same estate in land. They all have to have the fee simple, or they all have to have a fee simple determinable, or whatever it is. They all have to have that same interest. They all have to have the same title, meaning the source of where that title came from. The same grantor has to give grant to them in the same instrument their interest. And they have to receive that title at the same time. So it's got to be the same instrument. And it can't have one co-owner get part of his at one time and another co-owner get his at another time. It all has to happen all at the same time. And then they all have to have the equal possession. In other words, equal share. If there are 3 owners, then they have 1/3 each. If it's 4 owners, they have 1/4 each. They all have to have equal ownership share. And the distinguishing factor, the real distinguishing factor about a joint tenant with right of survivorship is this last item here. Upon death, the interest passes to the surviving owners. And that can be quite handy in avoiding probate, because a joint tenant with right of survivorship, when you have to probate a will, that ends up not being a probate issue. It's what we call non-probate property. It passes with this arrangement, regardless of what any will says. Our next one is tenants in common. Now with tenants in common, this is more common with regard to real property than is the joint tenant with right of survivorship. Joint tenant with right of survivorship is very, very common with personal property, things like bank accounts and stock and such like that, particularly with married couples. But not so much with real property. But this is very common with real property. Each owner, like with the joint tenant with right of survivorship, each owner has an undivided share, but they're not necessarily equal. Each owner has a right to use and possess all of the property, just like with joint tenant with right of survivorship. But the interest, as I said before, may be unequal. You could have owner A with 1/4 and owner B with 1/2, and then owner C with the other 1/4. So they don't all have to be equal. And also, here's the big point. There's no right of survivorship with tenants in common. With a tenancy in common, there is no right of survivorship. The interest of a deceased owner passes by will, or if they don't have a will, by the intestacy statutes. Okay? So that makes this, anything held tenants in common, that makes this probate property. Let's talk about community property. There are about 8 states in the country that have, for their marital property system of holding property by married couples, they have that as what we call community property. And Texas is one of those 8. These 8 are located primarily in the southwest and western part of the country, because it comes from the law of Mexico and before then the law of Spain and continental Europe. So not all states share that historical heritage or that legal heritage, and Texas is one of 8 states that does. And so what community property is, and it applies only to husbands and wives, it's property that's acquired during marriage. All property acquired during marriage is community property, except that property that is a gift during marriage or a devise. In other words, one of the partners of the marriage receives something by someone else's will, like from a parent or a favorite aunt or uncle or a grandparent. That gift is going to be separate property. Or descent, meaning they inherited something from, they were an heir, a next of kin of someone who died without a will, and that they have now inherited that property. Well, all of that is going to be separate property, not community. But anything else acquired during marriage is going to be community property. Well, what if it's not held this way? Well, if it's not acquired during marriage, or if it is one of these items here, if it's not community, that means it's going to be separate property of that individual. And then the rights. what rights do these co-owners have? Whether it's a joint tenant with right of survivorship or tenants in common, what rights do they have? They have the right to enter, possess, use, subject to the rights of all the other co-owners. They also are entitled to their proportionate share of the income, but they're also liable for their share of the expenses in upkeeping that property or anything associated with that property. And if they end up paying more than their fair share, they have a right to contribution from the other co-owners. They can go into court and they can get a judgment against their co-owner who hasn't paid their fair share. And a co-owner, whether it's joint tenant with right of survivorship or a tenant in common, they may convey, sell, mortgage the property, their interest in the property, only their interest, but they can sell their interest without the consent or the joinder of the other co-owners. And if they wish to partition, in other words, cut out a piece of the real property that they want to say, well, I want my 1/3 of the property to be that corner, that southwest corner of the tract of land. Well, that's called a partition. And they can go to the other co-owners, and the co-owners can do this voluntarily, or a co-owner can go into court and try to force the others into a partition by asking the court to order it. And if all else fails, a court can order the property sold and the proceeds split proportionately among the owners. And that's how we acquire real property and hold it concurrently with others in Texas.